This is a presentation about how no, the use of solitary confinement or administrative segregation does not constitute cruel and unusual punishment. By Joseph Black, Evan Staley, Brittany Flickinger, Sydney Nielsen, and Dallin Lambert. Introduction. Solitary confinement is defined as the housing of an adult or juvenile with minimal to rare meaningful contact with other individuals. Its purpose is to isolate disobedient prisoners from the general population to help behavioral issues and protect other prisoners. Solitary confinement was first experimented with in the United States legal system in 1829. The experiment took place at Eastern State Penitentiary in Philadelphia, Pennsylvania. It was established based on the belief that of the Quakers, the isolation with a Bible would allow for time to repent, pray, and find introspection for those confined. The Supreme Court case Hutto v. Finney helped tighten solitary confinement regulations for prisoners. Within this ruling, the Supreme Court officially acknowledged solitary confinement represents a recognized type of punishment. This meant that the rule was subject to the standards of the Eighth Amendment. The Eighth Amendment protects against imposing excessive bail, excessive fines, or cruel and unusual punishments. There are many reasons why this issue is so often debated, starting with the definition of the Eighth Amendment. The Eighth Amendment states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. What is cruel and unusual punishment? What's fair for all parties? In the previously mentioned Hutto v. Finney Supreme Court case, the verdict was at the behest of the prisoners for the awful conditions their solitary confinement consisted of. The Eighth Amendment was mentioned several times during these court proceedings as foundation for the prisoners' lawsuit. However, in Hope v. Harris, a case ruled on by the Court of Appeals in 2021, Hope filed a complaint that his excessive, now 27 years in solitary confinement, violates the Eighth Amendment and the Due Process Clause found in the 14th Amendment, as administrators biannually review his case. Both claims were dismissed as the court ruled solitary confinement within the bounds of the Eighth Amendment and recognized his due process as being served. These two very similar cases have very different outcomes, but are founded on the same legal authority. Another inconsistency seen in solitary confinement is the reasons for implementing it on prisoners. Administrative segregation is when the administration of the prison or the courts choose to confine the prisoners based on the risk they pose to those around them. Disciplinary segregation is more a form of punishment for infractions and rule-breaking within the prison. Typically, inconsistencies happen in the disciplinary segregation, and depending on the state, prison, and sometimes even the guards, different actions can lead to confinement. And finally, the toll solitary confinement takes on the mental health of inmates is something that is still being explored, especially since prisoners are more likely than just your average Joe to be dealing with mental illness in the first place. A statistic from the Bureau of Justice reads, use of restrictive housing was linked to inmate mental health problems. 29% of inmates and 22% of jail inmates with current symptoms of serious psychological distress had spent time in restrictive housing in the past 12 months. For the most part, courts hold that solitary confinement for those that are mentally ill is in violation of the Eighth Amendment. Another reason that solitary confinement is such a contentious issue is regarding solitary confinement for juveniles. Juveniles that are charged as adults are often placed in protective custody within the prisons, away from other prisoners for their own safety. This protective custody can sometimes be similar to solitary confinement conditions, and some say these conditions can impede their developing process and stunt their ability to rehabilitate well after their prison sentence. Anna Conley, a Montana resident and director of a statewide prison and jails project, says that they are severely and permanently damaged by such conditions to a greater extent than adults. And again, this is something that's still being gathered information on in the prison system. The United Nations also have different standards than the United States when it comes to defining solitary confinement, which can be contentious for other nations. In international capacities, the United Nations has ruled that solitary confinement is a last resort, and that term is defined as 22 plus hours without meaningful human contact. They've also made another term called prolonged solitary confinement, which is defined as 15 plus consecutive days without meaningful human contact. Many nations have adopted these general standards of handling solitary confinement to mirror the United Nations. In contrast, the United States defines these two things in two very different ways, often meaning a much greater span of time than the United Nations regards them.
Why is solitary confinement beneficial? Safety of the prison. Solitary confinement is used in response to the most dangerous behaviors and situations. Safety and security must come first in correctional facilities. It is an act of prevention. Solitary confinement of inmates can be a necessary, often life-saving measure to spare both staff and inmates from injury or even death. Safety of the prison continued. Solitary confinement restricts incarcerated persons from being a threat to other prisoners. The purpose of the justice system is not to send people to prison to be victimized by other inmates. Solitary confinement protects other inmates of their constitutional rights. Offenders must be isolated from others. If someone is violating another person's rights, that individual needs to be removed from the situation. There are certain consequences to certain actions. This acts kind of like how a prison acts in society. Safety of the prison continued. Solitary confinement is a tool that guards can use to protect against contraband, such as drugs, weapons, and technology, and to protect against violence. Poor responses or no responses of inmate to inmate or inmate to guard incidences and failure to control contraband lead to prison riots. Isolating the problem is an important step in keeping everyone in the facility safe.
Along with solitary confinement being used to keep the general population of prisons and prison guards safe, solitary confinement can also be used to keep the prisoners being detained safe. Because prisoners in solitary confinement are kept away from the general population, high-risk offenders are less likely to be attacked and or killed by other inmates. Some of these high-risk offenders may include murderers, ex-gang members, sex offenders, especially child molesters. People who are serving time for sexual offenses against children are one of the most targeted demographics in the prison system. In California, sex offenders make up about 15% of the prison population. However, this group made up more than 30% of the inmates who were killed in prison. Other inmates will take it upon themselves to serve justice and act as vigilantes by targeting the prisoners who have what is known as bad paperwork. Sometimes even prison guards will participate in the beatings of sexual offenders. Because of the dangers that these people can be in, solitary confinement can actually be a place for them to safely be held while their situation can be addressed and assessed. We obviously don't think that solitary confinement is an enjoyable experience for prisoners. However, like we have stressed over the course of this presentation, it is still a necessary one. Solitary confinement gives guards the ability for better control of the inmates. Because no one wants to spend time in solitary confinement, it can help keep prisoners in check and in line without using physical and chemical restraints. It also keeps people safe from themselves as they are monitored by health professionals. With the use of solitary confinement, prisoners still serve their correct sentences. Each person in prison is there for a reason and sentenced to serve a specific amount of time depending on their crime. Solitary confinement makes sure that prisoners serve their sentence without interference from other inmates. As previously discussed, the United States does not support vigilantism, so solitary confinement can actually be the more moral option for serving out time. It is also important to note that not every prisoner is put into solitary confinement. In fact, in Utah, roughly only 14% of prisoners have spent time in solitary confinement, and in other states, that number is as low as 8%.
I will now be addressing the counterpoints for why solitary confinement is bad. So the first point I think the other side will have is that it causes a lot of mental health issues. And while this is true, there are a lot of mental health problems when putting people in solitary confinement. I think there's some important details to go over. So the first detail I want to address is that the median time served is 1.3 years. And that's honestly not a lot of time served. I think it's highly unlikely that someone is going to get mental health issues after 1.3 years. I think that's a reasonable amount of time for someone to get in there and get out without any issues. Now, people that serve longer sentences, they committed a much more atrocious crime, so I don't think a lot of society really empathizes for that person as if they were like to do murder and they were in there for like 25 years. I think a lot of people wouldn't really have an issue with that person having a mental health issue. Another point that I want to point out is that inmates with pre-existing mental problems are twice as likely to offend in prison. So someone with pre-existing mental health issues is twice as likely to commit a crime that could also further their sentence, which is not good. Um, but I want to note here that these people already have existing mental health issues, and that they're a little more unpredictable when it comes to crime. So I don't think a lot of society has a problem with keeping them away from the rest of society just in case they were an immediate threat. Um, and then the last point I wanted to make for this specific topic is that the alternatives are a little more gray. Now, the death sentence is a highly contentious topic, so there's that. But one thing I think the other side's going to make is kind of talking about rehabilitation, and it's true. We want to rehabilitate as many people as possible, but the fact is, not everybody is going to be rehabilitated. There are some people that are just, I think it's too late for them, and they pose a serious threat to society, and we don't want them near people and being a threat to other people. Another point I think the other side is going to try to make is that they're going to try to argue that solitary confinement is a form of torture. However, I have a few points that would suggest otherwise. So, for the first point that I have here is that states already have torture preventions in place. Some of the things that you can see are literal physical torture, such as, you know, harming bodily parts and stuff like that. They also count restraints as torture, in which they prohibit, and they also have chemical weapons used as torture, in which they also prohibit. And I'm stating that the fact that they have all of these laws in place to protect the prisoners, I think would kind of point in the direction that it's not a form of torture. If it was a form of torture, I think that all these laws really wouldn't be in place to protect the prisoners. And then another point that I think counters the point that it's a form of torture is that the United Nations created a 15 days rule. Now, even the United Nations, because the United States has the highest incarceration rate, right? The United Nations, this is every nation, including ones that don't really have that much incarcerated, said that solitary confinement is only defined as torture if someone is waiting 15 days in, while incarcerated for their trial. And that was all they said. Even the United Nations, which is historically a less solitary confinement based organization of all countries, even they didn't even say solitary confinement was torture unless it was specifically under that notion. The other point I think the other side is going to try to make is that solitary confinement is a violation of human rights. Um, I have some statistics that back up that of why I don't think that it is, but we'll get more into that in a sec. So, morality, if you think about it, is more defined by society, and most of it is how society views certain actions, and sometimes it's the government just straight up outlawing it, and then society kind of accepts that law. But for the most part, society deems actions moral and immoral. Now, if 56% of Americans are in support of solitary confinement, then would that really be a violation of human rights? If human rights were truly being violated, I don't think 56% would support it. While there are 29% that do oppose it, which is a good amount, it's easy to say that the majority of Americans are in support of solitary confinement. And the final point I have in terms of violation of human rights is that prisoner lawsuits prevent violations. There have been many cases in the past where there were horrible protocols set in place for the prisoners, and they would make a case in court and argue how they are being or how their rights are being violated, and they would win. So if they're able to win on certain cases and then improve the system, then it wouldn't really be a violation of human rights.